Set? Great. Good morning. Yesterday, the CDC announced what many of us had feared, that the overdose rate in this country is climbing, and dramatically climbing. Overdoses jumped 30% nationwide from July 2016 to July 2017. We now have the highest fatal overdose rate ever recorded in the history of this country. Drugs are the single greatest threat to the lives of our friends, family members, and neighbors here in Kentucky. We lose 4 Kentuckians every single day. They're the greatest threat to our families themselves. We have more kids living in foster care and kinship care than ever before. We have more broken families than ever before, and this drug epidemic is the cause. Drugs are also the single greatest threat to our economy. A recent study of Louisville area workers shows that just that area of Kentucky workers failed drug tests by 15% more than the national average. That means our single greatest threat to job growth in this country is not having healthy workers that can pass that drug test. And we still have 50 Kentucky counties identified by the CDC as at risk for an outbreak of hepatitis C and HIV, and those are threats that we're starting to see materialize in some of our areas. Our people struggle with this devastation while opioid manufacturers and distributors count their billions in profits. From my first day as Attorney General, I promised that I would hold these companies accountable, and I'm doing just that. Thus far, we've sued Endo Pharmaceuticals, McKesson Corporation, and Cardinal Health. Today, we are filing suit against AmerisourceBergen. Based on our numbers, we believe that AmerisourceBergen has supplied nearly 32% of the opioids that enter this state, playing a major role in fueling our opioid epidemic, and they are showing record profits. In the first quarter of 2018, AmerisourceBergen announced its revenue of $40.5 billion. While they are counting their billions, our communities have been devastated. Eastern Kentucky was hit the hardest. Based on AmerisourceBergen's market share, from January 1st, 2010 through December 31st, 2016, a 6-year period, AmerisourceBergen would have supplied over 9.5 million opioids to Bell County alone. That's 340 doses for every man, woman, and child living in Bell County over that 6-year period. During that same time frame, AmerisourceBergen would have supplied over 8 million opioids to Clay County alone. That's over 381 doses for every man, woman, and child living in Clay County just from AmerisourceBergen. And for Floyd County, AmerisourceBergen would have supplied over 17.8 million opioids, or 461 opioids for every man, woman, and child just from AmerisourceBergen just over a 6-year period. Once again, no responsible company would have seen that flow, millions of opioids going through their hands to small eastern Kentucky counties, and say all is well. Because of this, we have filed suit against AmerisourceBergen in eastern Kentucky in Floyd County Circuit Court, because eastern Kentucky families deserve justice. They deserve this company having to come in and explain to their families why it took its actions, why it never lived up to its duty to stop these shipments, to alert the DEA, and to prevent our opioid epidemic from worsening. We are not the first to recognize the devastation AmerisourceBergen has caused. West Virginia Attorney General Patrick Morrisey recently settled with AmerisourceBergen for $16 million. It was alleged in that settlement that AmerisourceBergen oversupplied West Virginia from 2007 to 2012 with a total of 132 million doses of hydrocodone. I'm committed to hauling AmerisourceBergen and every other one of these opioid distributors or manufacturers into a Kentucky court to answer for the harm that they've caused Kentucky families. With this suit, we have now sued the 3 largest distributors of opioids to Kentucky: McKesson, AmerisourceBergen, and Cardinal. And in the announcement of each of these suits, we have talked about that 6-year period and about how many opioids flowed into just a couple of eastern Kentucky counties from these national distributors. Once combined, again, just talking about January 1st, 2010 through December 31st, 2016, McKesson, AmerisourceBergen, and Cardinal combined distributed 913 doses for every man, woman, and child in Bell County, 1,021 opioids for every man, woman, and child in Clay County, and 1,240 doses for every man, woman, and child in Floyd County. Combined, these three companies flooded, absolutely flooded eastern Kentucky and every other part of our state with drugs they knew were dangerous, that would cause addiction, and that should have never been prescribed for the vast majority of people who received them. I will do everything in my power to ensure these companies that put their profits over our lives are held accountable. It is no less than the families that have lost a child or a friend deserve. We have lost so much, but I believe hope is on the horizon. These companies that have made billions have to be held responsible for at least providing us the tools and the dollars to help dig out. So thank you all, and I'm happy to take any questions. Adam?
General, how do you know these numbers? Does it come from Casper or some other source?
The numbers that are in our complaint at the moment, because we're still awaiting on some important data called ARCOS data, which we believe we'll get, are based on the total number of opioids that we know come into the state. That is an ascertainable number. And then using their market share in the state as distributors applied to those numbers. So we do believe, as discovery goes on in this case, that those numbers will get more precise, but we are confident that the numbers are generally accurate, and any numbers will show an absolute gross influx of opioids into these counties from these companies.
I know this is one of several lawsuits that was filed, I think one of hundreds that have been filed by states
Right.
and local governments all across the country.
Right.
The House last week kind of took a different approach. They wanted to pass an opioid tax. I wonder what you thought of that idea.
Well, I don't think it's necessarily a different approach, but perhaps an additional approach. I haven't seen the nuts and bolts or had a discussion with the House about how they see that working. I'm generally for anything that is going to stop the influx of opioids into our state that will lessen the amount that we're seeing, because we are still seeing far too many. I would want to make sure that those terminal cancer patients don't have costs passed on to them. But aside from that, I'm very interested in learning more about that opioid tax and what role the Attorney General's office would play in it.
Yeah, the idea about keeping the cost from being passed on.
Correct.
I think that's written in the bill. There's been some question about whether that is legal. Do you know if that's possible?
We haven't had the opportunity to analyze the bill yet, having still not had a full discussion on how they anticipate it working and how any collections would be made.
To go along with what Adam is saying, as I recall, during their testimony, they said if they would pass that along so they would be higher than the cost in adjacent states, then the Attorney General could go after them.
I heard a few of those comments, and I haven't had a conversation to know exactly where they're coming from, or what authority they want to provide, or where they see it falling, and I want to have that discussion. The only thing that I heard about was the price gouging statute, and the price gouging statute is only activated when there is a state of emergency that has been declared by the governor. So I'm not sure that statute would apply directly. There may be others that do. I also have concerns separately on that price gouging statute with a bill that's working its way through the General Assembly that would cap penalties for price gouging at, what, I believe about $25,000. We have a current case against Marathon that's scheduled, I believe, for a November trial date, where we allege that they profited more than $80 million based on price gouging. And this bill would create a $25,000 cap.
What are you seeking in that trial? Are you seeking the $80 million?
I believe that the upward end of penalties based on the number of days is nearly 90. Now, in the end, that's the allegation. And talks between us and the company have not been fruitful. And so what we'll seek is an ultimate determination at trial for the damages that were caused and the penalties that are deserved. There's also penalties.
AmerisourceBergen sounds familiar. Have you taken an action before then since you've been in office?
Now, since I've been in office, we haven't had another action against AmerisourceBergen. AmerisourceBergen, McKesson, and Cardinal have been suggested nationwide at having up to 85% of the national market and distribution of pharmaceuticals. So what that also means is they have better data than virtually anyone about how many of these pills are going into where. And even if they only have 30% of the market, they know just 30% of the market is creating 400, 500 opioids for every man, woman, and child over a short period of time. The fact is these companies should have stepped in, and this should have never happened.
What's the status of your, I know I think it was Judge Shepard
Mm-hmm.
who issued a ruling that the governor and the contract review committee couldn't come in and cancel the contract.
Right.
Is that still ongoing? Has it been appealed? Have you talked to the governor anymore about that?
The finance cabinet filed an appeal late last week, I believe it was on Friday, and sought an emergency injunction to keep Judge Shepard's ruling from going into effect. This morning, the Court of Appeals denied the emergency motion for the injunction and will hear a regular motion for injunction, which is one of the things you can move under the rules for. I believe our brief is due later this week. We do not anticipate that an injunction will be entered because there was no injunction in the underlying matter. All Judge Shepard said was separate laws apply to the Attorney General's office, and if you applied the law in the way the Bevin administration wants to, it would create a constitutional violation because the governor nor his cabinet can control especially the litigation decisions of an Attorney General. That's how our framers created our current Constitution, with separate, independent constitutional officers. And there's some good case law out there about how they truly have to be independent. They can work together, and they ought to be able to provide information to each other. But one, for instance, cannot have veto power over the other.
And that's what he wants?
Correct.
In this case, it doesn't want to work with you. He wants to be able to control who you hire.
Well, in the case that was in front of Shepard and is now at the Court of Appeals, he claimed that, number one, the finance cabinet could at any time cancel our contracts under Chapter 45A, which would give the finance cabinet secretary, who's an appointee of the governor, control over decisions in this office. He also claimed under a separate statute that he in particular had to sign off on each of our contracts. And then I believe they claimed late in the briefing that he also had power to approve or disapprove any specific lawyer that we wanted to hire within the office. I mean, obviously, that's the governor trying to control the Attorney General's office, and we don't need to waste our time doing that. You know, our offices are created to be independent so we can get more, not less, done. There's no question that it's the Attorney General's job to pursue companies like this that have harmed Kentuckians on behalf of both the state and the people, while the governor has so much authority to address this epidemic in other ways. And if we could all just focus on the things that we're supposed to be doing in our job, I think we could get a lot more done.
Why not just work with him somehow? Is that possible?
We sent a letter to the governor's office saying we'll consider any defendant you want us to sue, any claims you want us to bring, any damages you want us to seek. And the governor's response back was, I'll only work with you if I get veto authority over your decisions. Constitutionally, I can't provide him that. Again, if it's truly about working together and not control, we've made that offer and it's been rejected.
Are you also going to be going after the doctors because they have to
We have been.
prescribe these pills?
Right.
Talk about your efforts there.
Well, this office has been going after doctors for wrongfully prescribing now for nearly a decade. The crackdown on the pill mills and the doctors who are a part of those pill mills has been a very active part of the Medicaid fraud unit, especially in this office. We've had a number of arrests in the last 2 years, and the administration before had a number of arrests there. We will continue to pursue those doctors and pharmacies and other providers that would carelessly flood our communities with drugs. And we have had in Kentucky good success. For instance, the Kentucky Board of Medical Licensure has been a very good partner in trying to crack down on overprescribing doctors.
One more question.
Sure.
About the dispute with the government. Do you think this whole, I don't know what you call it, dispute, is grounded in something that's like a genuine disagreement over policy relations, or is it just a kind of another ramification of the poor relationship between the two of you in your offices?
Well, I don't think this is just an argument that the governor's having with me. I think he's having it with other people. I believe to the governor it's about power. You know, these executive orders that he's putting out are rewriting statutes that the legislature and the legislature alone has the power to pass. The illegal cutting of our universities and their budgets that we went up to the Supreme Court. You know, the governor tried to claim that it was his decision on what was spent and how. And the court said, no, that's the legislature's decision. And I think we've seen that in other areas too. You know, the fact is the Attorney General's office is an independent office, and the people of the Commonwealth are better off for it. I believe that all I've done is to stand up for the Constitution, the separation of powers, and the constitutional duties of this office. Most of our agreements have actually had to do with my arguing things fall within a different branch of government. I've stood up for the legislature's power, oftentimes more than the legislature has, but still, if that's what the Constitution requires, well, that's what it requires. And it's the job of the Attorney General to enforce that Constitution. You know, when I took my oath, it has two parts. Number one, I won't fight a duel or be a second, or agree to be a second or fight a duel. And number two, that I will uphold that Constitution. And I believe that I fulfilled my oath, and I'm going to continue to.
No duels that you got planned?
None.
Senate Bill 1, are you having any conversations with anyone to, should we say, allay your concerns over that?
We have not had independent conversations. I am certainly willing to do that. Senate Bill 1 violates the inviolable contract, state law, and ultimately the Constitution because of that in so many ways. And we haven't seen any legal analysis from anyone else, and there's a reason for that. It's really simple. So the legislature said, we're going to make a promise to our public employees. If you dedicate your life to teaching our kids, keeping our families safe through being the police or firefighters, or protecting neglected children through being a social worker, that we are going to guarantee you a solid retirement. They didn't just make that promise, they turned it into a contract. And they didn't just turn it into a contract, they passed that contract into law. And when they pass it into law, under law, they made it inviolable, meaning it cannot be broken. And they were very specific about what's in that contract. When you look under the statutes, it says that an inviolable contract is now created between KRS-X and KRS-Y. And just about everything that Senate Bill 1 is changing falls between KRS-X and KRS-Y. That it is unquestionably inside the inviolable contract, that it impairs, if not reduces, the benefits of the inviolable contract, and therefore you can't do it. And if you look at any of those statutes that they're trying to change, you'll see that past General Assemblies understood this. Why? Because of the way they read. It says before this date, if you started with the state, you're entitled to these benefits, because you can't change it for people who started. After this date, you're entitled to somewhat different benefits, and that's the date that that change was passed. And if you go down through each and every one of these statutes, you'll see that that's how they each flow. So if this General Assembly wants to make legal changes, they've got to follow what every single General Assembly in the past did and recognized, is that's an inviolable contract, it can't be broken, and any changes have to be prospective, meaning for people who haven't started yet. Because when you start, that contract is made.
Do you have any indication that they're deliberately trying to provoke a court challenge in order to test the inviolable contract?
Well, it would be very disappointing if our General Assembly is intentionally breaking their word with our teachers and social workers. But it is blatantly unlawful. Senate Bill 1 is blatantly unlawful under Kentucky law. And any challenge in court, the Commonwealth is going to lose. So one of the greatest concerns with Senate Bill 1 is it's not going to fix anything because it won't hold up in court. And I believe that those that are discussing it right now understand or should understand that. And it's a concern that without other analysis that someone would pass something that is unlawful.
Aren't you obligated to defend them if there's a lawsuit
No.
filed against the state?
If you'll look at Supreme Court decisions, and there are at least 4 that are out there, I have a duty under my constitutional office to challenge unconstitutional statutes, not the other way around. My first duty is to the people and to the Constitution. And any duties to the Commonwealth are secondary to that. That's why the Attorney General is the people's lawyer.
So you could sue.
Correct?
Would you do that?
If they violate the inviolable contract, and I believe that other suits that have been filed are insufficient, then yes. And I will very strongly consider challenging Senate Bill 1 if passed. All right. Thank you all.